And Ms. Savage, your client's incarcerated, correct?
Yes, Your Honor. Me and Miss Greenlee had organized for him to be here from jail. I believe they were going to call in, but I don't see him connected yet.
Yeah, I don't see them either. Hopefully
I had sent in all the paperwork and I had spoken with TDCJ, but even despite an order, it is up to them and if they have phones, guards, or however to get them here. So.
Okay, well, let's go ahead and call the case and we'll get everything on the record.
Good afternoon, Emily Kyler Green, attorney for the department.
Irina
Crystal
for the mother.
Crystal Rosalis, investigator with the department.
Alexandra Vanderbilt, I am Ms. Rosalis' supervisor.
Kathleen Savage, attorney for the respondent, Father Matthew Rodriguez, Your Honor. I have had contact with him, but he is not here today, so I'm going to announce not ready.
Marco Cabrera, attorney at litem.
Irina Costa, attorney for the mother. I'm ready. Ms. Rodriguez, can you please unmute and announce?
Apologna Rodriguez.
Thank you. All right, anyone who's not an attorney or will be giving testimony, please raise their right hand. Ms. Rodriguez, I need you to raise your right hand too, please. The whole truth and nothing but the truth, so help you God.
Yes, sir. Yes.
Ms. Savage, you've announced not ready. Do we have service on Mr. Rodriguez?
We do not have service on Mr. Rodriguez, Your Honor.
What I'm inclined to do then is grant her not ready, and we won't make any orders as to Mr. Rodriguez today. We can take that up at the status hearing. Hopefully by then he'll have been served and either appear that day or show up. Okay. Miss Rosalis, just before we get started, my understanding is there's an agreement. There's no Indian child heritage in this suit, is there? That you're aware of?
No. No.
Okay, Miss Kyler Green, Miss Rodriguez is here. She was served and her attorney is present. My understanding is you have an agreement.
We do, Your Honor. The parties agree for the department to be named as temporary managing conservator, for the mother to be named as temporary possessory conservator. The parties agree to hold a family group conference to establish a family plan of service that's narrowly tailored to address the dangers that brought the children into the care, and for Ms. Rodriguez to participate in that. Parties agree to stipulate to the reasonable efforts listed in the affidavit, although it's my understanding that Ms. Rodriguez is not stipulating to the allegations in the affidavit. In regards to visitation, right now the children are pretty far away, but there has been a request for placement with the paternal grandparents, to which the department is willing to conduct a home study of the paternal grandparents. I believe the name is Michelle
and Alejandro Rodriguez, Your Honor, and they're present.
The paternal or maternal?
Paternal.
Okay.
And regarding visitation, Your Honor, the agreement is to have a normal supervised visitation to begin with, and then discuss further visitation as the case progresses.
Ms. Costa, is that your understanding of the agreement?
It is, Your Honor. We would request that if the home study hasn't already begun, that it be expedited. The grandparents are willing to take all of the children and they're present today.
Mr. Cabrera?
I'm in agreement with those terms as well, and I would second Ms. Acosta's ask for an expedited home study.
Okay. Ms. Rodriguez, I understand you may have things that you want to say or questions, but right now at this time, I just need to know if that's the agreement that you made.
Yes, sir, it is. It's exactly what we want.
Did you have the opportunity to discuss that with your attorney?
Yes, I did.
And were you forced in any way to agree to it, or did anybody make you any promises?
Not at all.
Are you asking the court to approve the agreement today?
Yes, please.
Okay. All right. And then I'm assuming y'all want to defer child support, medical support at this time?
That is correct, Your Honor. Thank you.
Okay.
And Your Honor, just a request as it comes to placement under 262-201N. If the court is not ordering possession by a parent or managing conservator, then their children shall be placed with a relative unless it is not in their children's best interest. My understanding, the children are either in a group home or shelter of some sort, very far away. The paternal grandparents are active in these children's lives and they have a bond with them. They're also in the local area, which would help facilitate not only visitation, but allow the children to be returned to their school of origin. So I would ask the court to order placement, order the expedited home study, but to get these kids back home to their area where they're from.
And Your Honor, they're in a foster home, not a group home. The concern that we had is that there's things that popped up on the background check of the Rodriguez family. And so what we'll need to do is I think the correct terminology is like a risk assessment. So that needs to be done first and foremost. But we are willing to do the expedited home study.
Mr. Rosalis, you heard the agreement. Do you believe that this agreement is in the best interest of the children?
Yes.
All right, and is the current placement safe and appropriate, meeting their needs?
Yes.
All right, what were just without divulging any potentially confidential specific criminal history, or any other type of criminal history, what generally are the concerns that you need a risk eval for?
There was a conviction in the background check that we just need to be able to address, and more so be able to relate how it wouldn't affect the safety of the children currently.
Okay, so just to be.
Can I speak? Can I speak?
No, ma'am, you can't speak out of turn. If somebody wants to question you, they can question you, but it's not really a meeting. This is a hearing. We have court procedures we have to follow. So, Mr. Rosalis, you heard Miss Savage referring to the statute, and she is correct that barring any evidence that suggests it would not be in the best interest of the children to place with a family or other relative, family member or other relative, the court is under an obligation to place there. So is it your testimony today that the concerns requiring the risk evaluation rise to the level of giving you pause or concern about placing the children there at this time until that's been done?
Yes.
Okay. And do you believe, I understand, Ms. Savage, that your client under 262-013 does not agree to the allegations in the affidavit, but Ms. Rosalis, do you believe that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the children?
Your Honor.
Yes.
Yes.
Just a clarification. It's Miss Acosta's client, not Miss Savage.
Well, no, but Ms. Savage did bring up the, I'm sorry, thank you for the clarification, but it was you, Ms. Savage, that brought up that placement issue, correct? Okay, all right. Sorry if I misspoke. All right, Ms. Rosalis, do you believe that the urgent need for protection required the immediate removal of the children, and reasonable efforts consistent with the circumstances and providing for the safety of the children were made to eliminate or prevent their removal?
Yes.
And do you believe that reasonable efforts have been made to enable the children to return home, but there's a substantial risk of a continuing danger if the children are returned home?
Yes.
All right. I also understand the parties have stipulated to the reasonable efforts, but just for the purpose of this hearing and the record, could you please briefly set forth the reasonable efforts you made to try to avoid the removal?
Yes, we did try and engage mom in a safety plan. And after that, she decided that she didn't want further contact with the department. And we tried to reach her on different occasions at different residences, and we were never able to get a permanent residency on her to be able to have those meetings with her.
Okay. And other than what you've just stated, were there any other reasonable efforts made to enable the children to return home?
No.
So do you believe that the efforts that you just stated satisfied both avoiding the removal and attempting to return the children home?
Yes, we did also file the MTP,
Right.
and we're not able to get mom served to attend that.
Okay. Ms. Kyler Green, do you have any other evidence you want to present?
No, Your Honor, I don't have any more evidence. I don't know if the indigency findings from, or actually, I don't think there have been ever indigency findings on this case or for this individual. So I think that needs to happen as well.
Right. Okay. Anybody else have any other evidence they want to present?
No.
Okay. Ms. Rodriguez, I'm going to ask you to unmute again. Do you have the ability at this point in time to hire an attorney to represent you in this suit?
No,
Do you have anything that you own that you would be able to sell, or any savings, anything like that that would allow you the opportunity to pay for an attorney?
no, besides my car, but that's my, my go-to to get everywhere.
Do you receive any type of governmental assistance?
I used to, but once they removed my kids, they told me I could no longer, of course, they're not in my presence. I wouldn't be able to apply for SNAP or anything like that. So that's the only
Okay.
thing I had was food stamps.
But when this case initiated, you were receiving that?
Yes.
Okay. I'm going to find that Ms. Rodriguez is indigent for the purposes of this suit and maintain the appointment of her attorney. Mr. Rodriguez is incarcerated, so I'll also maintain his indigency and continue Ms. Savage as his appointed attorney. Anything else that you want to report as the ad litem?
Yes, Your Honor. So I met with the children in the foster home. It's a good foster home. I don't see a real pressing need to move them immediately. They had a doctor's appointment. Isabella does have a physical disability with her right arm. She has a 504 accommodation for that in the school she's going to now. She had an R yesterday. Initial assessments for all kids are set up on Saturday. Kids are doing well. They're being taken care of. All of their needs are being met. As for the Rodriguez family, I have been kept abreast of what's been going on. My understanding is that the charges are serious in nature, but from some time ago. So I would agree with the department. It is something that we need to check on. If that's all that it is, and just that charge from long ago, then I would likely support the move. But just to ensure the safety of children, I think we do need to take those extra steps.
Okay. Ms. Rosalis, do you believe that the educational needs of the children are being met in the current placement?
Yes.
And they're getting the health care they need?
Yes.
All right. Then based on what I'm hearing at this point in time, court finds that the agreement of the parties is in the best interest of the children. Again, based on 262-013, the court will enter this agreement with the condition that mom is not conceding to the truth of the allegations in the affidavit. The court will find that based on the testimony here today, that there was a danger to the physical health or safety of the children caused by an act or failure to act of the person entitled to possession. For the children to remain in the home is contrary to their welfare. The urgent need for protection required the immediate removal of the children, and reasonable efforts consistent with the circumstances and providing for the safety of the children were made to eliminate or prevent the children's removal. and reasonable efforts have been made to enable the children to return home, but there's a substantial risk of a continuing danger if they are returned home. Court finds that it's in the best interest of the children to name the Department of Family Protective Services and belong as the temporary managing conservator of the children, to name the mother as the temporary possessory conservator of the children. Court will make no orders as to Mr. Rodriguez at this time. Do we need a DNA test?
No, not at all.
Ma'am, I wasn't asking you. I understand that you want to answer that question, but I'm not asking you. Mr. Rosalis, do we need a DNA test?
Not at this time.
Okay. And Ms. Kyler Green, was it the intention of legal to ask for one?
It wasn't, Your Honor. He's the presumed father. I don't think one's necessary at this time.
Okay. All right. The reason I asked that question, Mr. Rodriguez, is because if we don't ask it at the beginning, there could be an issue later that would cause delays for you. And I don't want that to happen. I understand from a practical perspective, there's no doubt, but the legal part of it is very different and we have to follow certain steps. So I just wanted to get that out of the way. All right. And then the court will order the parties to attend a family group conference to develop family plans of service that are narrowly tailored to address the concerns that brought the child into care. Court will also order the expedited home study on the placement. This is for Ms. Rodriguez and both her and the paternal grandparents. The issue we have before the court is that there's a possibility that there may be something in the past that would, in certain circumstances, cause a bar to placement. It sounds like that's not going to be an issue here, but this is why I'm inclined to let that happen before I order placement. And that's a best interest issue. What's in the best interest of the children? If I were to place the children there today and that placement happens, and then this risk evaluation is done, and there's a problem that causes the court to have to remove the children again, that's not only bad for the children, but it could possibly cause a problem for us placing the children there again and getting any potential funding that might be available to assist with the placement. So my hesitancy is not because I want to make things more difficult. It's because I want to avoid a bigger difficulty in the future by not taking a small step now. The evidence is that the children are doing okay where they are. They're having all their needs met. I'm ordering the home study to be expedited, which would include the risk eval being expedited. So if all that comes back, then we can get this move done, and then we've taken care of both issues so that we don't potentially have an issue coming up after the fact, causing us an even bigger headache. Does that make sense? Okay. All right. Then I'm going to order that the children remain in the placement, the foster home, find that it's in the best interest of the children, it's meeting their needs to remain there, and that it's safe for them. But I want to make it very clear. I want this expedited home study to be expedited, and I want the risk eval to be expedited. And the second you get clearance, the children need to be placed with family.
And Your Honor, can I ask for that to be I think it's 3 days, the quickest expedited home study, if I could have that in the records.
I'll order that unless there's something that, like a paperwork issue that's outside of the control of Belong or the department. If they absolutely cannot get that done, then I'm not going to find them in any kind of contempt if it's a factual impossibility for them to meet that deadline. But I would prefer it to be 3 days as well. I don't want these children to be in a foster home any longer than they need to be if we've got appropriate family. Not only do I not want that, but technically that's the obligation under the laws for us to get the kiddos there as fast as possible. I'm going to defer child support and medical support at this time. And I'm going to order that mom have visitation twice a month for 1 hour supervised, with the caveat that if they are placed with the Rodriguez's soon, which hopefully they are, that the visitation I'm going to authorize you all to increase it as appropriate based on mom's engagement. So what that means, Ms. Rodriguez, is if you engage in these services that you develop with the parties and you're maintaining appropriate contact with your caseworker and your permanency specialist, and everybody can get a hold of you, and you're testing, if you're being drug tested, that you're testing, then the parties can agree, excuse me, the parties can agree to slowly increase the visitation more than just twice a month for an hour. If you don't do those things, then it's going to stay there. So that is your motivation to continue to prove to the parties and then to the court when we come back for our status hearing that it's safe for you to
But
have
only
that much
2
visitation.
times a month.
Hang on, ma'am. Hang on. Don't speak out of turn. The court will order that authorization at this time, and I don't want what I just said to change the fact that if that risk about turns something up that we don't know about right now, if there's a genuine concern, just because I'm saying we need to get the kids there as soon as possible, that I'm not overriding any concerns that might come up that the people in this room are not aware of right now. So it's not a 100% guarantee. It's just that we need to take that step. Miss Acosta, your client has a concern. Do you want to question her about it?
Prior to doing that, Your Honor, can I just make one request?
Yes.
With regard to the visitation, can we be ordered to discuss that as well at the FGC? Because I know right now the children are placed far away, and that's why the 2 times per month was agreed to. I just want it to be something that's a continuous conversation.
Yes, I think it would be very appropriate, and I want Mr. and Mrs. Rodriguez, the grandparents, to be a part of that FGC. I'm ordering that. I want their input in it as well. I think that discussing the visitation the visitation needs that are specific to this case is definitely something that should be on the forefront of the parties' discussions on the case and then the FGC. So yes, that's great. Did you want to ask her a question? I'm not sure what her concerns are, and I just don't want her to put anything on the record that.
I don't, Your Honor. I'll speak with her after the hearing.
Okay. All right. Our status hearing is going to be April the 8th, 2025 at 10:30. April 8th, 2025 at 10:30. So what that means, Ms. Rodriguez, is that between now and April the 8th, which is a little over a month, a little less than a month, you're going to have a meeting with all these people and you're going to develop a plan that you have input in, your attorney has input in, that will be tailored to this specific case and your children, your needs, their needs, to determine what sort of orders I'm going to enter at that status hearing on April the 8th. So you need to make sure you're at that meeting and that you work with the parties and cooperate to figure out what sort of services can be ordered that are workable for you and that address the concerns that brought the kids into care so that we can fix this issue and streamline this case as much as possible. I have to admonish you that the state of Texas gives parents in child welfare cases 1 year to demonstrate that you can provide a safe, stable, violence and drug-free home for your child. If you can't do that within a year, then your rights to your child are subject to restriction or termination. Our year started on the date that this court signed the emergency order, which was March the 4th, 2025. The year is going to be over on March 9th, 2026. It doesn't have to take a year. It doesn't have to take that long, but that depends on what you do. I don't know how long Mr. Rodriguez is going to be incarcerated for, but regardless of how long it is at this point in time, you know that you're the parent right now that has to provide a home for these children. So you are on a pretty quick timeline, and you got to take advantage of all that time. You got to hit the ground running and work hard. Miss Kyler Green, is there anything I failed to address?
No, Your Honor. Thank you.
Okay, that'll be the order of the court. And I look forward to seeing what kind of progress we've made March the 8th at 10:30. Ms. Rodriguez, you know, these cases can go really quick. They can go well based on the amount of work that you do and the willingness that you have to address issues, even if you don't want to. If you're willing to address those issues, then these things, you know, they're a lot easier than if you're defiant or combative. So really think hard about the choices that you make. I believe in you. I've seen a lot of parents in your situation who worked really hard and did what they needed to do, and things worked out well. So you can do this. All right. Thank you all for your time and your service. If there's